Hi, and welcome to the Hotline, your online hotline, direct line to the women-only attorneys at Hoff-hmer Family Law. My name is Katie Carter, and I'm so glad you're here. I'm an attorney at Hoff-hmer Family Law. We're a Virginia-based family law firm, and we represent women exclusively in divorce and custody cases. And I'm here today with my friend and colleague, Caitlyn Walters, who's going to talk to us a little bit more about custody cases and our Custody Bootcamp for Moms seminar, which is specifically designed for women who are hoping to represent themselves at the juvenile court level in a Virginia custody case. Thank you so much for joining me, Caitlyn. I'm just going to jump right in with the first question. Can you tell me more about custody cases as opposed to divorce cases and what exactly is involved?
Yes. So a custody case is a case that is focused solely on parenting of the children and what we're going to do as far as the parenting time. So where the kids are going to be spending their time. Those are your physical custody arrangements and either visitation or parenting time. Visitation, parenting time, it's the same thing. And then your legal custody, which is the ability to make your big life-altering decisions for the kids, really boils down to non-emergency medical care, religious upbringing, and educational decisions. So those are what's typically involved in your custody case. And then divorce cases, those deal with, usually, if again children are involved, you can have custody and parenting time issues involved in those. Then you're also going to throw in spousal support or alimony. And then equitable distribution, which is our division of assets and debt. So again, your custody can be part of a larger divorce action, which occurs up in the circuit court. You can choose to have a divorce case without involving custody and save custody cases to be handled in the juvenile court. Or you can also have your divorce case handled separately. Again, do custody down in juvenile court by yourself and on its own. Have custody determined first, the divorce second, divorce first, custody second. You guys, it's like the Wild West out there. You can have a whole lot of things happen. Or if you and the other parent were never married, then you would be down in the juvenile court handling just a custody case. And so your custody cases, again, we say custody, but usually if you hear an attorney talking about a custody case, parenting time is always going to be usually, I say always and then I just said usually, but always usually going to be involved. Again, determining where the kids are going to be spending their time and who gets to make those big life-altering decisions and how are they made? Are they jointly made? Are they solely made by one parent? Again, those custody cases are typically between the two biological parents of the children, although you can have custody cases that deal with a third party. So maybe the grandparents are trying to get some parenting time, a step parent, an aunt, an uncle, somebody that has some unique and close tie to the kids. But again, usually what we're seeing is a custody case that is between the two parents that are no longer in a relationship, no longer living together. And so now we need to figure out how that time is going to be divided between the two parents. Either the parents are going to be able to reach an agreement, and then that agreement can be made part of a court order, or the judge is going to need to make a decision. The other thing to keep in mind with custody and parenting time is it is always modifiable based on a material change of circumstances. So you may come up with a custody and parenting arrangement that works for your kids when they're really young, maybe 6 months old, a year old. That custody arrangement probably is not going to work once they're 5. Then they start school. School can be a really big material change in circumstances that requires us to need to modify things a little bit. That parenting arrangement may no longer work when they're 10, 15. So you're probably going to be back in court at some point needing to adjust that schedule. A question I frequently get is, what is a material change in circumstances? And my very lawyer answer is, you know it when you see it, because there's not a set definition. It's kind of like the Supreme Court's definition of pornography. You know it when you see it. There's not a set definition, guys. And so it is one of those things, but it does need to be a material change that impacts the kids. It's not just, I've decided that, I don't like this schedule anymore because it doesn't work for me, and so I want to change it. One of the things that you're going to hear a lot when you're doing a custody case is best interests of the children. And why you're going to hear that phrase is because that is what matters in a custody case. That is what makes the determination for custody and visitation is the best interests of the children. The reality, it doesn't matter what's best for you. It doesn't matter what's best for the other parent. It doesn't matter what's best for teachers, coaches, siblings, anything like that. It is what is in the best interest of the kids that are involved in this case. And that is what the court is supposed to take into consideration when they make their decision. for custody cases.
Yeah, and that's also how you should be planning exactly what you're going to say to the court too. It shouldn't be focused. And these things can get really complicated because very quickly it's not, just mom and dad or mom and the child's other parent involved anymore. People tend to go off and get remarried and their stepkids and a new spouse and a big family dynamic. But I would say that for the most part, when lawyers are talking about custody cases, we're talking about custody as a standalone case. So custody, visitation, and child support, usually in the juvenile court, though it can also be on appeal to the circuit court. And a divorce case, even a divorce that involves custody, so there's a custody component, is going to be a divorce case, right, with just a custody component. So we might still be talking about the same standards. We're still talking about legal custody, physical custody, parenting time. We're talking about child support. We're talking about all the same things, but I would view those more, the ones in circuit court are divorce cases, and usually either juvenile court or an appeal from juvenile court is a standalone custody case where only issues related to custody, visitation, and child support for these minor children are being considered. In either way, I think it's possible to represent yourself. For a lot of people, access to an attorney, being able to afford one, is a difficult thing to do. And a lot of people, for a million different reasons, choose to represent themselves. It's kind of where the idea for custody bootcamp for moms originally came from. But Caitlyn, what advice would you have for a mom who is hoping to represent herself in a custody case?
So the first piece of advice that I would give for a mom who's going to represent themselves is to just have an awareness that it is not going to be easy. And I think the earlier that she can acknowledge that idea and really keep that in mind as she moves forward, that is going to help, because it's hard for us, even as attorneys, to prepare these trials. Like it is time consuming, and it is going to take preparation. And being prepared is going to be the next key thing. So knowing it is not going to be easy, and knowing that you need to be prepared, and then doing the work to be prepared. Again, Katie mentioned Custody Bootcamp. So Custody Bootcamp is a program that our firm offers. It is an all-day program, you guys. We are there. We start at like 9 a.m. and it goes until about 3 o'clock in the afternoon. And we talk about the ins and outs of a custody case. And again, it was originally designed for moms who were intending to represent themselves in court, because we wanted to help women really be prepared for that really arduous task of representing themselves. And so we start out with just basic vocabularies of, things you want to know as you're starting this case, so that you don't feel overwhelmed by legalese, because that can be a little intimidating. So we give you some of that vocabulary. Then we talk about the best interest factors, and we go through each one of those 10 factors, because, as I said earlier, those best interests of the child factors, it's 20-124.3. If you want the code section, look it up. But there are 10 factors that the court has to consider when looking at custody, and that is all they can consider when looking at custody. And so you need to know those custody factors forward, backwards, upside down, in your sleep, because if you want the court to consider a fact, it has to fall under one of those factors. And if it doesn't, then the court can't look at it. So we go through each one of those 10 factors, and I talk about them, and I talk about, what are some examples of facts that you may have in your case that would fall under those factors, and how can you present evidence that falls under one of those factors. And we even talk a little bit about, this factor sometimes tends to favor mom when we look at custody factors, and this one tends to favor a little bit more of dad. Or, this is where those text messages between you and dad, when you're coming at each other, this is where that would fall in. Or, what evidence can you start to find even before your case has been filed? How can you start, preparing your case before the case starts? And how can you start trying to interact with dad to start getting that evidence together, so that when you get to that final trial, sometimes maybe even 6, 8, 9 months, a year after it started, how can you start getting that together now so that you're ready when that time comes to be able to give that evidence in a way that was going to make sense? So we go through those factors. We talk about preparing before the case has even begun, and pretrial strategy, and ways that you can, get, again, the ways that you can interact with a narcissist co-parent, ways that you can interact with an abusive co-parent, ways that you can interact with somebody who just has that barrage of messages coming towards you. We give tips about ways to interact with the friendly parent trap. We talk about, then ways that you can set up different parenting schedules. We go through then, where do I go when I go into the courtroom? When should I stand? Where should I sit? How do I talk to the judge? How do I get my evidence in? What is evidence? What is hearsay? What's a GAL? How do I interact with a GAL? So you guys, we go into so much about a case. The other thing that I tell everybody that attends, because I typically present the boot camp seminar, and so I also really encourage the moms who attend to please ask questions, because the other thing about custody cases is that they are so incredibly fact specific, and I want this program to be beneficial to the moms who attend, and so I want to be able to make sure that I am giving information that really is helpful. And so even though there's no attorney-client privilege, because we're a group while we're there, it's online, by the way, if that helps. But even so, there's no attorney-client privilege, so we try to keep it general. But I still want to be able to make it tailored to those who are there. And plus, you don't want to hear me lecture for however many hours that is. Don't
a lot
ask
of
me to do
hours.
math. Thank you. That's why I'm a lawyer. I don't do math. But you don't want to hear me lecture for that long. So I encourage questions. And so it really is a good way to help. And I mean, again, I'll get questions like, Dad constantly does this. How would you recommend I respond? Or, I'm really struggling with having my kids away from me for this long. What do you recommend that I do to help? And, I don't have the personal knowledge from, having grown up I didn't grow up in a divided household. My parents are still married and my husband and I are still together, but I have seen tips that I've gathered from my clients, and friends that I've had that have gone through it, and then other professionals that I work with, that have, therapists and things that I've worked with that have given me tips that they give their patients. And so it's a really great approach to just how to handle a custody case. And even if you have an attorney, I found that my clients really appreciate going because it gives them insight into what I need to know as the lawyer presenting the case, and it makes them a more effective participant. So even if you go and you start the process thinking you're going to represent yourself and you do eventually end up hiring an attorney, if that's the route you choose to take, I still think it's an incredibly helpful program. But especially if you're going to do this on your own, I think it will help you with preparation. And so I would really highly recommend that you attend. The other piece of advice I give to moms who are going to represent themselves is to enlist the help of a therapist, because you are going to need somebody that can help you with the emotional just tax that this is going to take on you, because it is going to be long. It is going to be exhausting. It is going to be hard. And you need somebody who is going to be trained in helping you handle that. And so I would really recommend that you find a professional, a counselor, therapist, somebody that you mesh well with, that can help you through that as well. We tell people all the time, and Kristen Hoffheimer used to say this, that, you hear when you fly and they talk about the oxygen mask dropping from the ceiling, to put on your own oxygen mask before you help those around you. And I don't know if any of you have flown with children. Katie, I don't know if you've flown with your kids. I have. And they make the announcement, everybody ignores them. You're already like pulling up your movie that you downloaded or the book on your Kindle to start reading. But if you fly with kids, like I've flown with, my son was 7 months old the first time we flew with him. They walked around and they like made eye contact with me and they were like, "Ma'am, you put on your mask before you help that little tiny innocent beautiful baby boy in your lap."
They knew you would be a problem. They knew you wouldn't listen if they didn't come to you specifically.
She's, first of all, she's like already scrolling her Kindle. Secondly, like, your natural instinct as a mom is to help, especially your babies, like to help. And, my son is almost 6 now and he's, he'll forever be my baby. But your natural instinct is to help those around you first, especially in those like crisis situations. But the reason why, and I don't know why it took me this long to like put this together in my brain, and I promise you guys I'm smarter than this, but it's because if I'm not getting oxygen, I'm going to pass out, and then I'm help to no one. And so you have to help yourself in a healthy way before you really are going to be both a good mom and a good advocate for yourself, which is going to make you a good advocate for your kids. So you need to get the help of those professionals. So that's the other piece of advice I tell women that I meet with, is to please find a counselor or a therapist that can help you through this, because it is hard. It is hard to do this, especially on your own. And so getting that assistance, making a consultation with an attorney, having them help you through some steps. Maybe you get the GAL packet and you just want some help to figure out the best way to word that. Maybe you get the GAL report and you just want some help. Maybe you need some assistance with figuring out evidence and the best way to go with that. That can be a good way to get some of that in as well. So you can make those consultations even if you don't end up fully hiring that attorney to get that assistance.
Yeah, absolutely. I think it's important to get guidance throughout the process. The first thing you can do, and I think something that Custody Bootcamp does exceptionally well, is prepare you to understand the process and the steps that you're going to go through. Because if you're coming into this blind, you don't know what a custody case looks like. You find out that you have a court date. You don't know what's going to happen on that first court date. You don't know, where you can advocate for yourself and where, some certain things are going to happen kind of no matter what. Can you influence whether a guardian ad litem is appointed? Can you help choose who that guardian ad litem is? And even just being able to advocate for yourself in the very early stages can pave the way to make your case either a lot harder or a lot easier. And being able to recognize, your own role in that is incredibly important. And a big mistake that I see moms making is that they don't know, they don't have the benefit of the years of experience that we do. They don't know what the more important issues are. So they tend to muddy the waters by bringing in everything they can that they think might help their case. And I think a big benefit that Caitlyn provides at Custody Bootcamp is helping you figure out which issues are most important, which ones are actually going to influence custody, and which ones are kind of just a distraction. It might be important to you, right? I mean, it's certainly important to you, and it may be that the way he's behaving is abusive. He's, he's counter-parenting rather than co-parenting with you, and you need to kind of work through your feelings around that, your grief around that with a therapist, but focusing on how to present that information and what specific details to include is something that Caitlyn can really help you hone as you begin to come up with a case strategy. And that can even happen at Custody Bootcamp, even in, a venue with a number of other people as you're kind of trying to figure out what your next step should be. It can be incredibly helpful that way. And again, like Caitlyn said, whether you have an attorney already or whether you're hoping to do it on your own, very, very helpful to get that information. And I think that leads me well into my last question for you, Caitlyn, which is, we've talked about how hard this is. We've talked about how much is involved. Is it really possible for a regular mom who is not a lawyer to represent herself effectively in a custody case? Do you think that's really something she can do?
I do think it is. And I've seen it. I have seen it happen. I have seen moms that have done an incredible job. But I think it is doable with the preparation, with the work, and with the ability to understand the reality of how hard it is. And I think part of what also makes it a little bit difficult is that there is reality and there is court. And a lot of times those are not the same thing. And they're, kind of playing off of what Katie said, there are things that you may think are so important that you're like, surely anybody would look at this and say, well, absolutely, that should then come up with this result. And then you go into court and you present it in a beautiful way that makes sense. And, you've got all that admissible evidence and you've put it out in a way that the timeline is there, the judge follows it, and the judge looks at you and says, I don't think that matters. And that just totally derails you. And, a quick story that to put it in perspective, I had a case once where there was a finding of physical abuse by dad of the older child. There was no question about it. CPS investigated, found that dad had physically abused the son. And so we were in a custody case related to the daughter, and we were trying to bring up this CPS finding of abuse by the son because, in our opinion, that should be
very relevant.
Like, I don't know, if he's abused a child, I think they should probably like maybe take this into consideration for what type of time he should have with the daughter. And the judge literally looked at me and said, that's his relationship with his son. That's not his relationship with the daughter. It's not relevant.
And you're just like,
it took me a minute to recover. And you've got to, you got to try to have a little bit of poker face when you're, there. And I'm the lawyer, and I'm trying to keep my poker face of, excuse me, what? Like that, it's not relevant that he has physically abused a child, and you don't think that's relevant? Yes. So, okay, thanks, Judge. So, and I mean, that is shocking to me. And so, to try to keep all of that together is really hard. And so, again, back to your question, is it doable? Absolutely. I don't want anybody to feel like they can't do it, because you can. You just have to be prepared. And you have to be ready to know the rules, because it is also technically one of the rules is a non-lawyer is held to the same standards as a lawyer when they are representing themselves. And so you can't just go in and say, well, I didn't know that was the law, because ignorance of the law is not an excuse. And they are going to hold you to the same rules as a non-lawyer. And so you need to know what those rules are. You need to know how you present evidence. You need to know how that goes. You need to know what a GAL is. You need to know what their role is. And you just need to be ready to know that. And you need to be ready to handle your emotions in a healthy way, both outside of the courtroom and inside the courtroom, which is why I think a therapist can be helpful. But I think you can do it. And we understand the reality of limited resources. We understand that, family law and these types of cases, this is not like personal injury where if you win, there's this big pot of money you're getting from an insurance case. The more money you're spending on me as your attorney, it's less money in your pocket and for you to spend on your children. And so we really do try to keep that into consideration. We really do, again, that's why we've got our free resources online, our books that we offer, our seminars that we offer to, again, try to give as many resources as we can to women in our community to help with those ideas of wanting to empower women to help their children and help themselves through this process. To be able to represent themselves if that's, the only option that they have when they get to that point in their lives.
I do think it's usually a particular kind of person who represents herself, and she is very tenacious in general, yes, and willing to put in the work that it takes. Obviously, going to custody boot camp is a great first step because it's filled with so much information. It includes access to Caitlyn, and we always say, we stay until the last woman's last question is answered. So, exhaust all of those questions. But even after custody boot camp, you're going to have to do the work to put your case together. And that means researching the Virginia Code provisions that are applicable, researching the case law from previously decided cases in Virginia and in your local court that have been decided and that might influence a decision in your case, and even familiarity with the local rules associated with that court. Many of the different courts have specific rules about deadlines and how things have to be presented, and it can be hard for us to keep up with the differences between different courts.
Absolutely.
It's a lot of information. So the kind of woman who is going to do this is going to be, willing and able. And, I always say, I'm just delusional enough to attempt a lot of things, right? Not delusional enough that I need a straitjacket, though that might be debatable, but just delusional enough that I'm going to put myself out there. I'm going to ask questions. I'm going to do things that I'm not sure if I can do it, but I'm going to try it. So I think you need to be just delusional enough in the nicest, most affectionate way possible. I mean that, to be willing to take on all of those things and to walk into that courtroom with your head held high, and to be able to articulate an opening argument and a closing statement, to be able to question and cross-examine witnesses. It's not that it's impossible. Obviously, like Caitlyn and I were two totally normal, mostly normal people.
I was gonna say, speak for yourself, because
normal's not the right word. It's like, we're not, genius level. Like, we're nice and, regular moms who, we did have the benefit of law school and, a decade and more in practice, which is helpful, but we're relatively normal people who are just, doing the best we can with what we have. And, that's not to say that, we're no better or worse than anyone else. And I think there are a lot of women who could handle doing this on their own, but you are going to have to take the initiative on your own shoulders to, do the research and to put your case together and to plan what questions you're going to ask and what, evidence you're going to introduce and what witnesses you're going to question. And, it's not that you can't do it, but it's a lot of work. It's a lot of work for us when we prepare for trial. And it's certainly going to be a lot of work for someone without the benefit of a law degree and years of experience and practice. And even just, we call it, in our office, we call it the brain trust, the ability to ask a bunch of different lawyers questions before we do things. And we're constantly asking each other what we should do. And that's why Caitlyn said, have a therapist to help you manage the emotional part of it, and then have, attend custody boot camp, maybe even have a couple consultations with a lawyer to kind of handle the cerebral and, the preparation part of what goes into a custody case. But I absolutely think that it's something that you can manage if it's something that is important to you. And what could be more important, right, than custody of your children? Yes. So, I know people do it all the time, and it is endlessly inspiring. And I love the stories that I hear, not just, in the office and, from other attorneys and from moms who have done this. We constantly get emails and things from people that Caitlyn's met at custody boot camp who are saying, how much this program has changed their lives and how much they've learned. So it does really reinforce for us the importance of continuing to offer it, and just wanting to make sure as many moms find out about it as possible so that they can take advantage of all the resources that we can connect them with. And Caitlyn, not to brag on you or anything, but I think it's truly an incredible thing that you're doing, and the women who attend are just so lucky to get so much FaceTime with you and to get the opportunity to ask you so many questions. Caitlyn's also, she didn't mention this, but she is also trained as a guardian ad litem, though, representing women only kind of means that, you're not going to get many guardian ad litem gigs. You're just kind of looked at.
No, the dads wouldn't like it.
Yeah, the dads wouldn't like that very much. So that doesn't happen, but she's trained as a guardian ad litem, so she has that experience, and so much of that comes into the advice that she gives and how much she's able to help the women that attend the seminar. So it's definitely a great resource and something that you should look into if you're hoping to represent yourself. Do you have any parting advice or any words of wisdom for anyone before we go, Caitlyn?
I just think hang in there. Again, it's a long process. It's shockingly long, I think sometimes. I think that's one of the first things that I was shocked by when I started practicing, is how long these cases take. But there is a light at the end of the tunnel. You will get there. And we are here to help. Again, we want to help in any way that we can. And so we just, please look at those resources that we have for you and let us know what we can do.
Plug. You can visit the website at hofflaw.com. That's HOFLAW.com. And we've got 4 free books, a divorce seminar and a custody seminar, the custody bootcamp for moms we've been talking about, a number of free reports, literally thousands of pages of blogs and articles that you can check out, and consultations. So whether you want to hire an attorney or not, you can always consult with an attorney and ask questions and get a gut check, or have a proposed agreement reviewed, or have your proposed discovery reviewed, your responses reviewed, your guardian ad litem questionnaire reviewed. So at any point, you can always ask questions and get guidance from us, and we're happy to help. But thank you so much for tuning in, and thank you, Caitlyn, so much for being here. I think this was really helpful.